Good afternoon, everyone. Welcome to today's JCRC and Jewish Federation program, Federal Employees Know Your Legal Rights. I'm Ron Halber, the CEO of the Jewish Community Relations Council of Greater Washington. The JCRC serves as the public affairs and community relations arm of our region's Jewish community, which represents more than 300,000 individuals. That's the third largest Jewish population in the United States, and over 100 Jewish institutions, including synagogues, schools, agencies, and chapters of national organizations. The recent wave of unacceptable and arbitrary firing of federal workers, especially here in DC, has had a devastating impact, including on members of our Jewish community. And we want to be clear today, we see you, we care about you, and our community is here for you. The Jewish Federation, with whom we're co-sponsoring this call list, mobilizes community builders and organizations to identify and develop solutions for our community's greatest needs. In times of crisis, the Federation provides critical resources, including financial support and coordinated services to help individuals and families overcome challenges and thrive. Our Jewish Social Service Agency, JSSA, is on the front lines of this response. We encourage anyone in need to call the J-Caring line. That's 703-J-Caring, 703-J-Caring. It's a program supported by the Federation and operated by JESA. It's a regional resource that you can pick up the phone and call anytime, and we will help you navigate available services, not just through JESA, but across the community, including support for job searches, mental health care, and a wide range of other needs. Please note that the Federation also operates a website where all the resources we are describing are listed and are constantly being updated. Today, we focus on the legal rights of federal workers. The DC region is home to 20% of the federal workforce, and these arbitrary cuts have hit our community especially hard. To help us understand what rights federal employees have at this moment, we are joined by two outstanding experts, Robert Shriver and Michelle Bercovici, who have generously offered their time and expertise this afternoon. Rob Shriver is the Managing Director of the Civil Service Strong and Good Government Initiative at Democracy Forward. He previously served as Acting Director and Deputy Director of the U.S. Office of Personnel Management in the Biden-Harris administration, where you champion the rights and well-being of federal workers across the nation. Michelle Bercovici is a partner at the Alden Law Group, where she represents federal employees in a wide range of employment matters. She's a seasoned legal advocate with nearly 20 years of exceptional experience in federal employment law, workplace rights, and government ethics. We have collected your questions in advance, passed them along to our speakers, who will address as many as they can in their presentation. Once they finish their presentation, we'll open the floor for Q&A and for the rest of the hour that we'll spend together. Rob, Michelle, thank you once again for being here. The floor is yours.
Thanks so much, Ron. It's great to be here with you. Thanks to the JCRC and the Federation for putting this event together. Michelle and I are going to go through a slide deck that gives you guys just sort of to level set what the rights are that federal employees have, the different types of legal actions that you can bring. We're not providing any specific legal advice. We're not your attorneys. So all of those disclaimers apply. This is for informational purposes. I wanted to just say a word about Democracy Forward. We're an organization that's committed to the rule of law and has been standing by federal workers from the beginning of the administration. A lot of the lawsuits that have been brought on behalf of federal employees, Democracy Forward has been at the forefront of. And I'm really honored to be joined by Michelle, who is an excellent federal employment law specialist. And we have worked directly with Michelle and her firm on a number of cases involving federal employees. So we're going to tag team this presentation so you can hear from both of us. We'll try to go through it expeditiously so there's more time for questions. Go ahead, Michelle, to the next slide. We're going to hit on civil service protections. And so It's important for you to know that civil service protections are enshrined in the law. They're in Title V of the Civil Service Reform Act. Key provisions are at 5 U.S.C. Chapter 75, adverse actions. That's what provides due process and appeal rights to the Merit System Protection Board. Those rules provide that generally, before an adverse personnel action can be taken against you, you need to get notice. You have an opportunity to respond at the agency level, and then you have an opportunity to challenge it through an appeal to the Merit System Protection Board. It's important to know that there are different types of federal appointments in the federal government, and so your rights may differ depending on whether you're in the competitive service. That's where you have the fullest civil service protections, and the so-called accepted service, and that's where you have some civil service protections that depend on what schedule you're appointed under. There's this, of course, the senior executive service, the level of senior executives that are to whom the GS employees report to. They have their own set of rights. And then across these services are probationary employees, people that are in their first or second year of a new job, maybe new to the government. And typically the protections there are quite limited, although we can talk a little bit about what this administration's done and where those rights are. We're trying to vindicate those. If you are covered by a collective bargaining agreement, you also have rights under that. And that applies whether you're a dues paying member to the union or not. You're covered by that collective bargaining agreement. And there are special rights there. Let's go ahead to the next one, Michelle. Okay, so I just talked a little bit about how your rights can differ based on whether you're in the competitive service, accepted service, and whatnot. And so how can you tell what kind of position you have and what your appeal rights are? You should look at your SF-50. It's a notification of personnel action. That will have that information on that form. And then you should also, we're advising all federal employees to download and save their EOPF. Just given all of the actions that have happened, whether it's, terminations without notice, reductions in force, and being put on administrative leave, sometimes you lose system access. And so it's just good practice to make sure you've downloaded all your documents, and that's where you can find information about the type of your appointment. It's also important to know that there are some exclusions from Title V, and then some of these places have other specialized rules. So just be aware that the discussion tonight, this afternoon, is largely about Title V. If you're in the legislative branch, Library of Congress, GAO, FBI, intelligence agencies, the Postal Service, or the Foreign Service, there may be some different rules that apply to you. And so you need to consult with your union rep or legal counsel on those things. The next topic I was going to cover real quick, and then you'll hear from Michelle, is the right to be free from discrimination. And again, most of you guys probably know this stuff, but just to make sure that everybody's working off the same set of information, there are a lot of laws that apply to federal workers and job applicants that protect you from discrimination. So Title VII protects against discrimination and harassment based on race, color, religion, sex, sexual orientation, gender identity, and national origin. There's the Age Discrimination in Employment Act that protects against discrimination for workers who are age 40 and up. The Rehabilitation Act protects against discrimination based on disability. And then there's the Genetic Information Non-Discrimination Act, which protects against genetic information discrimination. What's important about all of these statutes is that these go the EEO route. So federal workers who are looking to remedy discrimination based on these topics, you've got to report those to your employer's Equal Employment Opportunity Officer within 45 days. And then there are appeal mechanisms that progress from there. Go ahead, Michelle, and take it away for the next topic.
Sure. Thank you so much, Rob. It's a pleasure to be presenting with you. Very briefly, I want to talk about whistleblower protections. So federal employees do have coverage under what's called the Whistleblower Protection Act. This gives federal employees a certain level of protection when they engage in whistleblowing from being subject to adverse personnel actions because of their disclosures. So broadly speaking, what is a whistleblower? So whistleblowers are they can be a federal employee. There's also coverage for contractors, but primarily these are federal employees, so not private citizens, not private employees, but federal employees who witness wrongdoing in the workplace or an action that they believe is a violation of rule, law, or regulation, gross waste of funds, gross mismanagement, abuses of authority, or substantial and specific dangers to public health and safety. So if you witness that and you decide to speak up, whether it is in the course of your duties, whether it is to your supervisor, whether it is to Congress, whether it is to an inspector general, the Whistleblower Protection Act gives you protection against being retaliated against for making those disclosures. What's really neat about the Whistleblower Protection Act is this right to go to Congress, to go to an IG is not something that can be, waived or written away under a settlement agreement. And it's something that is hopefully will continue to be very much respected in the government. You can, again, make disclosures externally and internally. What are not whistleblower disclosures? So it doesn't protect against disagreements about policy, against, I think this is wrong in general. It's also not really the forum where you challenge objections to like things that are discriminatory. So if it's a disagreement about policy, again, that is not covered. But if you're actually saying this is wrongdoing, there's a violation of public trust, here's a law, there is protection, and those are enforced through various federal forums. So here's the disclosure. So the nice thing about disclosures is they can be anonymous. They are, again, you have to have a reasonable belief that the disclosure evinces wrongdoing. You don't have to have solid proof. You don't have to have a written admission. You can make the disclosure orally or in writing. I think that that's surprising to some people who might come to me and say, well, I can't prove that I said this, or I can't prove that someone did that. All that matters is that you made the disclosure. And it can be on or off duty. Again, it does not protect things that are just not otherwise unlawful, that might be a little wasteful, or that have a potential impact on public health and safety. It really has to be, when you're talking about public safety, a substantial and direct impact on public safety, like a VA nurse reporting that the agency was failing to have crash carts as required in an operating room. If somebody coded, you need to have the crash cart. That's a direct risk. It protects duty speech. So even if you are a special agent and you're charged with investigating wrongdoing by the government, disclosing that wrongdoing is still protected. And what are these protections? So I would like to say the protections are so broad that it never happens. Whistleblower reprisal does happen, but there are very clear prohibitions that outline the type of actions that someone cannot take because of a personnel action. That includes threatening to take a personnel action because of a disclosure, or actually taking that action because of a disclosure. It could include things like reassignments, terminations, taking away duties, things that fundamentally change your working condition. If you have experienced retaliation as a result of disclosure, and also as a result of participating in an internal agency investigation, for example, an IG investigation, going to Congress, any of those things, you can file a complaint with either directly with the Office of Special Counsel, which is the federal agency charged with their primary protection of whistleblowers. You can also go to your agency's own inspector general. So that's not necessarily going to be under the Whistleblower Protection Act. However, because there are these federal laws that outlaw retaliation against whistleblowers, agency inspector generals can also investigate instances of retaliation against those whistleblowers. And you could also seek assistance with your union. there are grievance processes. If your whistleblowing also happens to be protected union activity, there are additional remedies as well. If you do believe that you are being retaliated against for whistleblowing, the best place to start with is reaching out to an attorney or a union representative to get more information, or going and checking out some information on the Office of Special Counsel website. For those individuals who are contemplating whether or not to become a whistleblower, it's also a good idea to become familiar with the procedures and methods for reporting those violations.
I'll take this slide. So do federal workers have a freedom of speech? And the short answer to that question is yes. The First Amendment protects citizens against the government curtailing their right to speak, associate with others, vote, and participate in religious activities. So generally speaking, yes, federal workers have freedom of speech covered by the First Amendment. But what's important to know is that there are limitations on that freedom of speech related to your work. And so first and foremost, it's been established that the government has the ability to limit the speech of its employees where that speech could impact their work responsibilities. And I'm going to jump to the bottom and say there's also specific rules that implicate the First Amendment around political activity. So the Hatch Act is the law that governs what kind of political activity federal workers can engage in. So that's just to show you that there are some limits that you need to be aware of. But where federal workers' First Amendment freedoms are the strongest is when you're speaking or associating with others in your personal capacity, outside of the workplace, off official devices or channels. And of course, if you're talking about matters not related to your official duties, like that's just participating as a regular American citizen in your First Amendment activities, and that's where your rights are the strongest. So again, like the takeaway that we wanted to make sure you got from this slide is that, yes, you do have First Amendment rights, you do have freedom of speech, but there are some limits that have been upheld in the courts around exercising those rights in connection with your job and in connection with political activities. Now I think we're going to turn to RIFs, right, Michelle? That's up next.
Yes, and this is one that we decided to highlight in particular based on all of the questions that we heard. So RIFs are a subset of what we call appealable actions. So when it comes to things like termination, suspensions, and so forth, under the Civil Service Reform Act, federal employees have the right to challenge some of these to the Merit Systems Protection Board, and we'll get to that in a second. Reduction in force is kind of a subcategory of that. And reductions in force are where an agency separates a group of individuals, sometimes even one individual, as part of a workforce restructuring initiative. It's established under OPM regulations. And it's an administrative procedure for reassigning or separating employees who occupy abolished position. These are procedures that follow where an agency decides to abolish positions due to a lack of work, shortage of funds, personnel ceilings, or reorganizations. They're, generally speaking, before this year, really rare. The last time we saw big RIFs, we saw some in the early 90s, and we saw a couple back in like 2011, 2013 range where there was the last hiring freeze and attempts to reduce a budget. Often the decision of whether to conduct a RIF should be happening at the individual agency, and the Office of Personnel Management is the office that provides kind of the guidance on how a RIF should be run. What is a little bit different about reduction of forces is that they apply to positions, not to employees. And in an ideal world, this is a process that is a result of a careful examination by the agency of reduced functions. The way reduction in force happens is an agency has to first establish competitive areas. So competitive area is an area in which the agency is abolishing the positions. An agency has a lot of discretion about how to define that competitive area. Generally, it can be up to a smallest geographically distinct unit. It has to be a unit that can at least be severable on an organizational chart. It is divided into competitive levels where you have employees in the same or similar jobs. And within each of those competitive levels, you essentially get a placement based on things such as the type of appointment you have, your seniority, your performance rankings, and most significantly, whether or not you're a veteran. This whole reduction in force administrative process actually comes out of the early laws kind of enshrining additional protections for veterans in the workplace. Very often, what you will in the past we have seen is agencies do not get rid of an entire competitive area. Rather, they are reducing the number of positions. So who gets the remaining positions is often determined by the standing in the competitive levels. These are what's called a retention register. Retention register is where each employee, along with the information critical to establishing their standing in the event of a reduction in force is set forward. Often there's supposed to be a 60-day notice requirement before an agency, between the time the agency announces a reduction in force and effects a reduction in force. If you're being subject to a reduction in force, this is really generally the window of time where it's really, really essential for you to double check what the agency has told you your service computation date is, your retention standing, and to see if there are any errors. Assuming an agency has correctly identified a competitive area and a competitive level, the agency at the end of the notice period will release employees. Once you are released through a reduction in force, that is what we would call an action that is appealable to the Merit Systems Protection Board or under a negotiated grievance procedure. The question of where are your appeal rights is going to be governed by whether or not the individual employees in the area are subject to a negotiated collective bargaining agreement, and whether that collective bargaining agreement includes specific provisions covering grievances regarding the agency's conducting of a RIF. Usually we'll see that CBAs also include provisions requiring the agency to work closely with the union in the event of a RIF. If there is not a CBA in place, then you can appeal the reduction in force to the MSPB. In fact, you must appeal the reduction in force to the MSPB if you believe that you were improperly released or that the reduction in force was improper. You don't have the right to file a complaint, directly in federal court. You can also claim that your separation was a result of discrimination. I have this slide up mostly for reference in case there are questions. I'm not going to go too in depth to the benefits, but very broadly speaking, with the reduction in force, unlike someone who's terminated for performance or conduct, employees do have certain entitlements because the separation is considered involuntary. There's really two categories. Employees who are separated pursuant to a RIF, but who are eligible for an immediate annuity. So it doesn't matter who actually retires. If you are eligible, either for regular retirement, which is age 62, with 5 years, all the way down to minimum retirement age with 30, or discontinued service retirement, which that's a special category of retirement that allows individuals who are involuntarily separated to retire early without a penalty due to their age. So again, you can retire at age 50 if you have 20 years, or any age with 25 if you get a notice saying you're going to be separated pursuant to reduction in force. Obviously, before you do that, you need to consult with your benefits staff. If you're not eligible for an annuity, you are eligible for severance pay, which it's a bit of a complicated calculation. OPM has a worksheet. It's calculated based on weeks of pay, years of service, and age. You are also entitled to be able to continue federal employee health benefits. You can generally apply for unemployment compensation. Whether or not there will be an offset depends on state-specific rules. Alternatives to a RIF that you see being circulated right now is things like voluntary early retirement. Again, that's kind of it's a voluntary separation prior to a RIF that you have to apply for and get approved. There's also a so-called deferred resignation program where agencies are offering individuals a period of administrative leave in exchange for a promise to resign. Generally, if you're going to separate under one of these alternatives to a RIF, you're not going to be, not only will you be not separated pursuant to reduction of force, but you won't have anything to appeal. You won't be subject to that adverse action. I know that was a very brief overview of a convoluted and archaic process, but we are just going to keep going to the next slide. I want to briefly speak about avenues for remedies. And again, this is the federal sector can be a bit of a maze, but once you figure out the basket, things do start to make a little bit of sense. Generally speaking, let's say I'm an employee who was fired. I can usually pursue if I want to challenge my termination, I have a couple different avenues. I cannot choose every single avenue. One avenue for challenging a personnel action is through a negotiated grievance process. This applies whether or not you are a union member, so long as you are covered by a bargaining unit and a collective bargaining agreement. If you're not sure whether you're a member of a union, look to your SF50. It will have a little code on there. If you see a 777 or 888, you're not covered under collective bargaining agreement. If you file a complaint under a grievance through the grievance process, generally that's going to be the form you choose. OSC, the Office of Special Counsel, is the federal entity that investigates and processes prohibited personnel practices, which include whistleblower retaliation. OSC investigates and can pursue corrective action. They're also somewhere where if you are a whistleblower and you were retaliated against, you need to exhaust your remedies, meaning seek assistance from OSC before you can pursue your claims elsewhere. However, there's also a direct appeal to the MSPB. What's critical about this is you have 30 days from the effective date of an adverse action. So it's a termination, suspension for 14 days or more, or reduction in force. So 30 days from that effective day to appeal directly to the MSPB. You could include in that appeal whistleblower retaliation affirmative defenses. So you don't go to both OSC and MSPB. You choose one. Those cases are processed by administrative judge and can be appealed to the board as a whole and ultimately to the federal circuit. If you believe you were subject to discrimination, again, as Rob noted earlier, you have 45 days to go to your agency's EEO office to say, I want to file a complaint of discrimination. That's all you have to do, but you have to do it within 45 days. Then there's, again, an administrative process unique to the federal sector EEO, which involves the agency conducting an initial counseling, which is a 30 to 90-day period, followed by you get a notice of right to file a formal complaint. The agency has 6 months to investigate. And then you have the opportunity to request a hearing with an EEOC administrative law judge, an EEOC administrative judge, or to get a final decision from the agency's EEO office. There are also actions in federal courts. In some cases, these are appeals from actions that have already gone through the administrative process. In many cases, as Rob will tell you in a moment, these are appeals being brought directly in court by employees or organizational groups challenging some of these sweeping executive actions. There's also mixed case appeals, which involve discrimination and appealable actions, but that exists. I'm going to move on to the next slide. So Rob can talk about what's being challenged.
Yeah, so what we've laid out for you here in these initial slides is just the normal rules and the normal processes that apply, the normal appellate avenues, everything else. But these are not normal times because we've never seen an administration target federal workers with so many actions, hostile actions, in such a short period of time. And so you're probably familiar with many of these. These are some of the key orders that have come out from the administration so far. Directives to return to in-person work, not to what things were like prior to the pandemic, but to what things were like 30 years ago, because telework has been around in the federal government for 30 years. A hiring freeze, a new version of their Schedule F, which will turn tens of thousands of career civil servants into political type appointments, new rules around senior executives that politicize the hiring process and the performance process for our career senior executives, orders to establish and implement the Department of Government Efficiency. And we've seen all that they have done to the federal workforce operating through OPM, the attack on DEI programs, the reforming the federal hiring process, which again is to introduce a more sort of central control and politicization over day-to-day hiring of federal workers, and then implementing the president's Department of Government Efficiency Workforce Optimization Initiative, which is the broad scale reductions in force that are underway, and then commencing the reduction of the federal bureaucracy. That's included orders, for example, to mass terminate probationary workers. So let's go to the next slide, Michelle, so we can talk about a lot of the litigation that's going on right now. So we've broken this down into a few different categories. There has been a lot of litigation over the administration's effort to terminate probationary employees. There were over 2,000 complaints filed with the Office of Special Counsel, including complaints that Democracy Forward and Michelle and her firm worked together on, where we got some temporary relief that put 6,000 agriculture employees back on the job. There have been multiple class appeals filed with the Merit System Protection Board on behalf of probationary employees. Most of federal agencies' employees are covered by those class appeals. There have been 2 actions in federal district courts that were brought to challenge the termination of probationary employees. Let me just pause for a minute and talk about class actions, because I know folks had some questions about that and how you might, quote, join a class action. Generally speaking, the way that class actions proceed is the lawyers have some representative employees, representative class members, who they enter a legal representation agreement with, and then they go to the body, whether it's a court, whether it's the MSPB, and they suggest that the case should be handled on behalf of a class of everybody who's similarly situated. If that happens and you're part of the so-called class, you will get a notice. You will get some kind of notice that tells you either that you're automatically covered unless you submit something that says you don't want to be covered and you want to opt out, or depending on the nature of the process, it may say, hey, this case was filed, you're part of the class. If you want to be included, you have to submit this notice, this form. So that's the way class actions work. People that are in the class would get a notice. The probationary employee cases are still actively being litigated in the district courts, in the Merit System Protection Board. The temporary relief that had put probationary employees back on the job while the cases were going through litigation has been overturned on appeal. So basically, agencies are allowed to terminate probationary employees while the case continues to get litigated. The Office of Special Counsel is working on closing out its investigation. And given the changes that have happened at OSC, you may have seen that the head of the office was terminated by President Trump, and they've appointed somebody in an acting position there, and they're now changing their position and closing down the investigations without further action. So we'll see. Those cases still have more to come. Reductions in force. So there are agency by agency appeals being filed on behalf of where there's different offices within a department that have been riffed. Firms like Michelle's firm handle a lot of those cases. There has been an effort that Democracy Forward has been involved in to challenge the government-wide reduction in force for people who worked on DEI matters. We have not succeeded in getting a class certified for that at this point, but that litigation is going on. The claims in that case are essentially that they've included people who not only were working on DEI, but also who moved on to other jobs or went to a training. It was overbroad. And then another way that these broad reductions in force are being challenged is there are district court actions where the organizations like Democracy Forward are arguing that the administration has violated the law by dismantling agencies without congressional authorization, and that the reduction in force is really the manifestation of that dismantling. So there are cases, for example, against USAID, the Consumer Financial Protection Bureau, the Department of Education. There's this litigation saying that this is illegal dismantling. There's another category of cases where the administration has terminated members who are appointed and confirmed on boards and commissions. I already mentioned the head of the Office of Special Counsel. That's somebody that was in this category. EEOC commissioners, one of the members of the Merit System Protection Board, the Federal Labor Relations Authority, on and on and on. And in addition, some members of the Career Senior Executive Service being terminated without any notice or any process. So there are district court actions there and also MSPB appeals on behalf of individuals. You may have seen that this week, OPM issued a new proposed regulation to implement its new version of Schedule F, which they're calling Schedule Policy Career. There already are 3 federal district court actions challenging the president's action to start this up through an executive order. That happened back in January. Those cases are being actively litigated. In the meantime, it's now the public comment period is open. And so there are lots of organizations and people who will be submitting comments expressing their views on this new proposed regulation. And then the last category to hit on real quick is there are lots of actions about DOGE. And there's multiple federal district court actions to challenge DOGE's data access. Let's go to the next one. I think that's it. So this went a little bit longer because we got some questions in advance that we tried to handle in the course of the presentation. But we're happy, Ron, as these resources are up on the screen, these are places you can go to get more information, but we're happy to use the rest of the time on other questions.
Well, first of all, Rob and Michelle, thank you for that amazing, comprehensive presentation, and we're glad that we have people like you out there advocating for people like us. We have a lot of questions. One of the most common ones is, will this be available? And the answer is yes. This is going to be available on the JCRC's YouTube channel, JCRC GW, and just look for it. First question, I want to try to get as many as we can. I'm not going to give names. Can an agency like the Patent Office in the Department of Commerce implement a RIF and not give severance when they offered a VSIP and a VERA?
You got that, Michelle?
Sure. I think these are, I want to say it's a funny thing, but funny is the wrong word. We can often say what the law says. It doesn't mean that agencies aren't necessarily going to try and violate it. There are regulations that say that agencies are supposed to offer severance to eligible employees who are not eligible for an immediate retirement. If you take VERA, generally it's an alternative to being RIFed. So you're just choosing to take VERA before you're actually going to be subject to reduction in force. So usually individuals taking VERA are not going to get severance. I'm not sure what Patent and Trademark is trying to do, but that would be very surprising. Agencies should be offering severance if you fit the criteria for eligibility that OPM has established. And Rob, if I missed anything there.
No, I think you got it.
And just one thing to keep in mind, again, if you're eligible for an immediate annuity, even if you don't want to retire, you are not going to be eligible for severance.
Okay. Thank you. Next question is, I was RIFed with only a few weeks short of the 20 years of service, 50/20, for discontinued service retirement, including annual leave. Is there any way to get that 20 years or challenge the situation?
So OPM put up updated guidance that says if you are scheduled to be separated by a RIF, you should be able to use accumulated annual leave to stay on your agency's roles past the RIF effective date. And again, but that's if you have enough leave to cover. I would recommend you talk to a benefits specialist. Also keep in mind that you get service credit for sick leave and annual leave. So if you have accrued but unused sick and annual leave, generally that can be translated. There's a formula whereby that translates into service credit. So I would first, before making any decisions, consult with the benefits officer. They can run some numbers, tell you how much time that adds up to, and also see whether you can get service credit for that time or if there's a way to stay on the rolls for a little bit longer.
So before we ask any more questions, Rob, would you be willing to tell everybody, because I have a bunch of questions to continue, about how they can get initial pro bono legal assistance through your organization so that we do this while the majority of the people are still on the call?
Yeah, thanks, Ron. So I'm happy that we just launched last week with the AFL-CIO and the We the Action Network, the Rise Up Federal Workers Legal Defense Network. And here is the address right here. This you can find it through civilservicestrong.org, and you can find it direct here. There's 1,000 lawyers who are ready to help federal workers on a pro bono basis. So you can go on there. There's a short form to fill out information about the nature of the issue that you have, and that will connect you up with a trained lawyer for an initial consultation session that is free of charge. They can help you navigate what your appeal avenues might be, if there are cases out there that already cover you, if you have technical questions. We have HR experts and federal employment law experts like Michelle and her firm that are in the background available to assist. There are criminal lawyers available to assist if anybody is, subject to some kind of criminal investigation or anything like that. There's really whistleblower resources. You can get hooked into all of those. So if anybody has questions and they want to talk to a lawyer in a privileged way without any charge, you can go to the workerslegaldefense.org website and get that assistance. Thanks, Ron.
And just so everybody knows, the JCRC will be launching an effort to work with Robert in trying to find lawyers in the Jewish community who will agree to help provide that pro bono service. Here's a question. If I'm eligible for immediate retirement, though I still have to work, can I collect unemployment? A worry is that there doesn't seem to be HR specialists specifically answering questions or processing paperwork. What if we do not get our pensions in a timely way to pay our bills?
I mean, I can jump in here, and Michelle, if you have anything to add, please do, because I have an answer that might be frustrating to you. Unemployment is determined state by state. And so really the best way to get answers about unemployment is to check in with your state's unemployment office. There are rules that are different from state to state. Maybe they'll actually have people that can answer the phone and talk to you because they're not going through these same reductions. But that's generally what the approach is with unemployment. Anything I missed there, Michelle?
Next question is, are DRPs legal? Can government change their mind and stop paying people on administrative leave via this program?
Yeah, so this is the Fork in the Road Deferred Resignation Program. And you're right to be skeptical. All along, what we have advised people is there's no statutory authority for the Deferred Resignation Program. It is a use of administrative leave that is unlike any use of administrative leave that's ever been done before. We were very worried about the fact that it was launched during a continuing resolution, and we didn't know what Congress was going to do with it when they enacted a budget or a new CR on March 14th. So that was a risk as well. I was relieved that we got over that hurdle and they did not defund the program or stop anybody from using it. So I still have concerns that it's not like VERA and VSIP, which are statutorily authorized programs. There are rules and regulations, and if the agency messes it up, you have a right of recourse. So DRP is not that. DRP is a made-up thing that they've pulled together from administrative leave authorities that don't normally aren't normally used for this. So there is always a risk that they're going to do something there that is not good to the employee. I will tell you that what we are hearing is that that is rare right now, that to this point, agencies are honoring the DRP deals. But again, you have to sign a broad waiver. And if they do change their mind, I don't think there's a whole lot of redress for you.
Yeah, and that's just to jump on and piggyback what Rob said. That's the same advice you'd be giving. At the end of the day, you have to make whatever decision is best for you and your family. And just, I think what's most important is just to be aware about the waivers that attach to this DRP. What are you waiving? What are you giving up? It's good to get information about what are your benefits before you sign it. I did want to correct something I said. So the new OPM guidance allows you to, if your agency allows, use your annual leave to stay on agency roles if you have enough annual leave to meet that time. Otherwise, it's paid out as a lump sum. Sick leave can be counted towards your service credit, but I do not believe sick leave can be used to bridge the gap for that retirement eligibility. For those at the very end of their careers, DRP might be a better option than a RIF for that reason. If the DRP is offered and honored, it sometimes says, okay, we'll let you stay on agency roles through X date. So that's why looking at your benefits is important.
Thank you. What, if anything, do you think can be done in response to OSC's recent position that it will not move forward with the investigation related to the termination of probationary employees? Is there any course of action?
Yeah, we talked a little bit about this earlier. It's a very disappointing decision. I don't think it's well reasoned, particularly in comparison to the reasoning that they laid out initially when pursuing a stay before the Merit System Protection Board. There is an opportunity for individuals who get those decisions to submit a response to their position. I know Michelle and Democracy Forward will be working together on doing that. To lay out why we think this is a bad decision. There are appeals pending before the Merit Systems Protection Board. That's a different legal theory, but it's challenging the mass terminations there as well. So don't think of it like that you can appeal from OSC to MSPB. It's just there's a different case there that, as I said, covers most agencies. So you may very well be covered by that case too at the MSPB. And then there's the district court actions as well, where there could be relief for probationary employees, depending on how all of that plays out. Michelle, anything to add on that one?
No, just to keep in mind that while this door is closing and closing in a very disappointing fashion, the reality is there are alternative claims that are catching employees who would otherwise have fallen through the cracks because OSC is refusing to do its job.
Somebody writes, I thank you for your thoughts. I was part of the HHS RIF, and I am currently on administrative leave until June 2nd. Is the government required to give you information related to the severance you received? I know there's a calculator on the OMB website, but given the inaccuracies in the RIF letter, long years of service, for example, I have doubts this will be done correctly. People who are retiring have been given lots of information.
We definitely are seeing errors in the RIF notices. That's not an uncommon thing. And I think you're right to have questions about this. Michelle, I don't know if you have anything specific on this. I don't know that they're obligated to tell you specifically what your severance payment is. I don't know. I know that you have a right to your records, and you can always file a Privacy Act request to get records related to you so that you have the actual data. But you might know more than I do, Michelle, on this one.
Oh, well, to be honest, RIFs prior to this have been so rare. It's a difficult question to answer. I think the number one piece of advice is to be proactive about any errors that you see. Proactive in terms of A, download your records, B, make requests to offices that make it to the office listed on the RIF notice, make it to your chain of command, make it to main HHS, make it to your own division or our unit, because I think they've just fired HR people. So if you're not getting responses at one location, make sure you've at least done it through a couple locations. And I think that is really the first step. I'm not sure how accurate the agency is supposed to give you when it comes to like an advanced calculation of your severance payment. Really, it's just an estimate. a lot of those severance payments are going to be processed by different offices after you're done. So I think the most important immediate thing is correcting any errors and what's really critical is your years of service and age. I do not believe most people are seeing errors in their performance ratings. Those performance ratings are really relevant if you're competing against other employees in a reduction in force. But if your whole office is being riffed, the real concern and your concern is just about, is my severance right? The errors in your performance rating are not going to be as big an issue. What's more important is your years of service.
How do we find out if our agency has started an appeal or an agency dismantling case?
It's a challenge right now because there's so many different actions and they're not compiled clearly in one place. I can tell you that the lawyers who are volunteering to work in that Rise Up Federal Workers Legal Defense Network are trained on what cases are out there, and so you can reach out to them and see through the link that we had shared that's in the slide deck. They should be able to let you know if there's a case that's filed that covers you. If you want to dig in a little bit and try to navigate this, there's a website called justsecurity.org that has a litigation tracker. It's not just civil service litigation, but the civil service litigation that's filed in the courts is in there. I'll drop that link into the chat too.
What happens when the MSPB doesn't have a quorum?
Go ahead, Michelle.
Again, I'm happy to answer that. So we do have, unfortunately, fortunately, as it could be, a lot of experience with the MSPB being without a quorum. What that means is the MSPB is generally, there's usually 3 members, a chair and 2 members, and you need, those individuals are the ones who issue decisions on appeals from administrative judge decisions. If there is not sufficient number of board members, like right now there's 1, that means that the board cannot issue decisions on those appealed cases. What has happened is 2 things. So 1, you have the option of waiting for the board to get a quorum again. There's no time limit or expiration date on how long your case remains pending. Lots of people chose to do that during the last go round. The other option is kind of twofold. So 1, either when you get a decision from an administrative judge, you as the appellant can choose to appeal that decision to the Federal Circuit Court of Appeals. And if you have a whistleblower case, you can go to any district court. But you can go directly to the Federal Circuit Court of Appeals. Similarly, during the last administration, after there had been no quorum for a long period of time, I believe the board had some sort of issued an order, some sort of rule saying, okay, if you have an appeal pending and want to pull it out and go to the Federal Circuit, you can do that. So there are options. Judges, as long as the judges are still there, but judges will be able to continue issuing decisions. It's just about that appellate level review.
So I have a couple questions about probationary employers. Probation employees, do probationary employees have any recourse, protection, ability to be rehired? That is the essence of about 3 questions we have here.
Yeah, so the probationary employees do not have the same appeal rights for an adverse action to the Merit System Protection Board that non-probationary employees have. That doesn't mean you can just treat them however you want. And in fact, we think that the mass terminations that the Trump administration carried out were a prohibited personnel practice. And that's why we filed a complaint with the Office of Special Counsel. The claims in the MSPB appeals are that they were really being riffed, and that the agencies, if they just want to get rid of as many employees as they can, then they have to follow RIF procedures to do that. So that still has to be tested. I don't think, Michelle, there's any reinstatement rights, except if you are subject to a RIF and you are let go because of a RIF, then you would potentially wind up on a RIF register. Is that right?
Yeah, there are certain RIF registers, reemployment priority lists. They have to check precisely how the rules relate to what level of priority you would get. But generally speaking, unless if you're reinstated pursuant to a court order, an MSPB order, your reinstatement is retroactive to your last day in a pay status. So you can actually get probationary status through 2 years of an appeal. I don't know if that's precisely the question, but that's the other way to get restoration rights.
I can give it two more. On a RIF, is the bump and retreat government-wide, agency-wide, or workplace-specific?
So bump and retreat is within, generally speaking, it's within your competitive area. However, aside from the bump and retreat, there are also separate, there's the interagency transition. It's ICTAP. It's like a big list where you can get priority consideration on jobs posted at other agencies if you've been separated pursuant to a RIF. And there's a similar reemployment priority consideration list within an agency as well, where agencies have to give priority consideration to these RIF individuals who've signed up to be on this list. If you're being subject to a reduction in force, the agency is going to give you information about how to ensure you're signed up or invoking any rights under those things once you're separated pursuant to reduction in force. So again, in some, bump and retreat is within your competitive area, which is why we're seeing so many people just terminated in full. But there are certain priority reemployment rights across the government.
Be on the lookout, because if they RIF you, they're not allowed to then bring in somebody else to do the same job you were doing. And we've already started to see that.
How long should it take to correct an error on my SF50 supervisor submitted to have it corrected 2 months ago?
I don't have any experience with that, Michelle.
So I think the main factors right now appear to be whether your agency still has HR staff in existence. One thing I would encourage to do is always be proactive on checking on the status of requested changes to SF50s. Just have a weekly ticker, check in with HR. What is the status? Can we submit a remedy ticket? Can we expedite, especially if it's a matter that is critical to your retention standing? One note is we have found that some people where the errors on the SF50s pertain to like a DEI type position or a personnel action that happened in between the transition from administration to administration, those might have gotten caught up in the hiring freeze. So that is one quote unquote error that is not going to happen. Otherwise, there is short staffing. HR staff are incredibly overwhelmed. I think the only thing you can do is make sure it stays on someone's radar and prioritize it if you're about to be subject to a personnel action because of that error.
What if the agency refuses to respond to a FOIA request to see retention registers or paperwork related to how the RIF was determined? I've emailed the relevant people at DHHS repeatedly and received no response.
Yeah, I mean, it's illegal. They're supposed to respond to FOIA requests. We have lots of FOIA cases working their way through the district courts. The other thing you could potentially do is if you are represented by a labor union, they have a special information request provision under the labor statute. So the union might be able to get it on your behalf as well. So yeah, it's frustrating. They're not turning over this information. They're getting sued about it. It seems like they're going to make us sue them before they turn it over.
Final and last question. We were told our agency is not creating a list because the entire competitive area, the whole office, was eliminated. Is that legal?
Yeah, so I'm skeptical of the way they're doing this. They seem to be using this competitive area in a way that eliminates bump and retreat rights as to the maximum extent possible. I think these decisions are going to get tested before the MSPB. I think there's a lot of questions about the way they're doing this competitive area stuff. Do you see it? Anything else there, Michelle?
No, I think that's exactly right. This is something new that this administration is trying. I think they've started calling it like a box riff or where you just get rid of an entire office, but you're really, even though I think some of them are more challengeable than others, I would like to be able to, it's not something that we've seen before. It's going to have to depend on how it plays out in the courts, I think. Unfortunately, I can't give a clear answer.
Thank you very much to both of you. Before we close, and I formally thank you, can you just give everybody, Rob and Michelle, one more time, that website or their address to get pro bono assistance?
Yeah, Michelle, you want to pop it on up
Yeah.
there again?
Yeah, or and we can put it in the chat. Let me figure, I lost it.
Yeah.
And if you want to pop it in the chat.
Yep. It's so workerslegaldefense.org is the place to go to get that pro bono assistance. Civilservicestrong.org is my organization's website that has a lot of resources, a lot of technical guidance and stuff like that on there. But workerslegaldefense.org is where you can get assistance from the Rise Up Network.
Right. And I would like everybody also to remember that we have the 703 caring line in case you have any other sort of needs, mental health, financial assistance, job services. So first of all, Robert, Michelle, I want to thank you very much for joining us today. I know that you are slightly busy during this time, and we're very blessed to have you give us an hour of your time and to help so many people in our community who are suffering. And thank you also for spearheading this effort to try and get some sort of sense of justice for so many people who have just been wrongfully and then on a wholesale basis terminated. We deeply appreciate your being here today. We also thank everyone for joining us, and we are open to holding additional webinars on topics that can help our community just through this difficult time. Just let us know. And so to all, an early Shabbat Shalom. Thank you.